नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Articles 1, 2, 3 and 4, and I'm now going to go back in some detail to Article 1. The reason I very quickly went through 1, 2, 3 and 4 is in order for us to understand how exactly this part of the Constitution is structured, which deals with territory. And if you look at the flow of the Constitution, the first part is dealing with territory, and the second, very intuitively, is dealing with citizenship. And this is very much in keeping with the definition in political science of how a state should be structured, that there must be exact or finite territory, there must be people, etc., etc. All the four principles of which, in fact, the United Nations recognizes in the Montevideo Convention, which I mentioned once earlier in class. Okay. Now, so therefore, it begins with territory and moves on to citizenship, dealing with people, and so we notice that Article 1 is dealing with the territory of the Union, and Article 3 is dealing with the area, boundary and name of a state, a rearrangement of existing states and creation of a state from a state or the change of its borders. Article 2 is about creation of new states. I'll come back to it later in today's class itself on the question of Sikkim. And then, of course, Article 4, which is like the procedural part of it, which tells you that any amendment to first schedule dealing with area and the fourth schedule dealing with the representation in the number of seats that it has in the Rajya Sabha, this will be treated as a mere law and not as an amendment for purposes of Article 368. So Article 4 is, of course, the procedural part of 1, 2, 3, 4. Now let me come back now to Article 1. We have already discussed that first, Article 1, Subclause 1, India, that is Bharat, shall be a union of states. And there's a lot written about this, and we have discussed it in class, so I don't want to go over it again. Why there was conscious rejection of the word federation or confederation. And for those of you who seem to have missed that, or you feel that you've not fully grasped it, I would tell you to go back once again and look at S.R. Bommai and look at the State of West Bengal judgment, which is there in the introductory topic in our case material. A fine question. Yes, Amrita.
Ma'am, by the word that India, that is Bharat, shall be a union of state, does that mean that the territory of India shall consist of state and union territories, and nothing else element should be there in the territory except for state and union territories? Does that mean this?
No, it doesn't mean that. The reason is that the union is the political entity called India, that it is a union of various states, but the actual territory of India is actually delineated in Article 1, Subclause 3, which is the territory of the Union. So there is a concept. So, it's something like if you are looking analogous to company law, there's something called the company, and then there are the individual elements in the company, because the company has a name and a seal of its own, which is independent of its constituents. And therefore, Article 1, Clause 1 is telling us that India is a union of states, meaning thereby that the states also have a role to play, they also have a voice, but it's not a federation of states, because as State of West Bengal judgment told us, it is not a case of prior sovereign states now coming together in a social compact to give up their sovereignty and to form a federation. In fact, State of West Bengal, the judgment is at pains to point out to us that those provinces were not sovereign even in British India. And when the princely states joined, they actually gave up their sovereignty and merged with the Indian Union. And then the Indian Constitution has created these various states. So I think that is actually the political story that it is saying. And union territories, of course, are directly under the union government. But we know that there are two types of union territories, that which have legislative assemblies and that which don't. So I think the first line is not telling us that only states belong to the union. What about the union territories? No. It is describing to us that India as an entity, which is also otherwise called Bharat, is a union of the different states and it's not a federation. Now look at Article 1, Subclause 2. The states and the territories shall be as specified in the first schedule. This is telling you the territorial extent of each state. And then you come to Article 1, Subclause 3. It is telling you the territorial extent of the Union of India. The territory of India shall comprise A, the territories of the state, which has already been described to us under Clause 2 of Article 1. B, the Union territories specified in the first schedule. And those union territories, all this has been amended, of course, by the 7th schedule. I will lift it to you to find out what was Part A, Part B, Part C states. I've already sort of given you a hint, but now we only have states and union territories. And please note that when it comes to union territories, it does not matter whether they are union territories with a legislative assembly or not. And I'll come back to this when I come to the government of NCT versus Lieutenant Governor NCT, the most important case for us in Delhi. But just to flag your attention, there's Article 239 of the Constitution, AAB, which tells you which are those union territories that have legislative assemblies. And then come to Article 3C, which is the subject matter of our Berubari Union case. Such other territories as may be acquired. It is an aspect of sovereignty that any sovereign country can acquire territory. How can you acquire territory? You could purchase it. You could buy it. You could get it by a gift. For example, if we go back in history, the British India, the British Crown got the city of Bombay, the island of Bombay, as dowry for the Catherine of Braganza marrying King Charles, right? So that came as dowry. It comes as a gift. And, just like, dowry in more recent times, people give car and furniture. Well, kings and queens obviously gave away parcels of land. Or you could get it through an act of cession, where somebody is ceding territory to you. Okay. And we had examined this.
Excuse me, ma'am.
Cession, yes.
Ma'am, is there any difference between the two phrases? The first phrase is, ma'am, Union of India, and the second phrase is Territory of India.
Yes, there is a difference, as I just pointed out, Yugal. For example, there is a country known as India, which is India, which we are declaring. It's a declaratory sub-article, Article 1, Clause 1, that India, that is Bharat, is a union of states. We are saying clearly here that it is a country. It has two names. Number 3, that it's not a unitary constitution having only one government, but there are also state governments. But the relationship between the central government and the state government is actually not a straightforward classical federal one, where previously sovereign states came together, but in fact it is a kind of quasi-federal. All that article, the first sub-article, is declaring that there is a country called India. And then Article 1, Clause 3 is telling you the territory of India. And the closest, best way I can explain it is by analogy. You say there is a company called XYZ company. And then you can say this XYZ company is a public limited company. There are 2 shareholders. But we know from your initial study of Solomon versus Solomon that the company is distinct from its shareholders. Similarly, the territory of India is distinct from the country called India. Okay? Now, cession. We are coming now to Article 1.3c. That is, the territory comprises the states, the union territories, and such other territories as may be acquired. And how can we, it's not the unification of states, no. No, it's not the unification of states, Sneha. It's not the unification of states, it's a union of states. That is, states have come together. But the choice of the word union, as I've explained in the previous two classes, is a deliberate one. Normally, if we were to say India is a federation of states, then it would mean that previously independent states gave up their sovereignty and came together to form this federation called India. But the different states or provinces, even if their borders have changed, were not previously sovereign. They were already under unified British rule. The Government of India Act 1909-1919 had a unitary form of government with provinces, no doubt. But those provinces were in one sense deriving their power from the central government. They were not independent. There was diarchy. There was transferred and reserved subjects. And even after 1935, the federation never came into being. Okay, yes, they're coming together. And so the word union, very deliberate choice, neither meaning unification nor meaning federation. Now, what is the difference between ceding and cession? Ceding is a verb. Cession is the noun. It's sangya or kriya. Okay, that's the difference. So the act of ceding is a verb. You're ceding, okay, kriya hai. Or cession is the act of ceding it's a noun, sangya hai. Okay. So, how can you acquire? I said you could purchase. So this is actually coming to us from international law, public international law. You can purchase it, you can acquire it through acquisition. It can be gifted to you. I gave you the example of Bombay. Or a foreign country can cede you territory through cession. So we have several examples in India. If you take Pondicherry, for example, when the French withdrew, they ceded the territory of Pondicherry, I think 1954 or 55, I'm forgetting the year. They ceded that territory to India through a formal act of cession. Not only Pondicherry, the other two bits of French territory in Tamil Nadu. I can't remember. Okay, but the other two territories also were given, which were all under French. Okay, so that got ceded. Yeah, yes, yeah. Yanam. Not Yemen. Okay, ceded to India. Okay. So, and Karaikal, yes, thank you. And so this all became part of the Union territory. And then, now the question for us is, before we come to Berubari, that the power to acquire territory has been expressly given. And the Supreme Court tells us that this is an attribute of sovereignty. It is an attribute of sovereignty that we can acquire territory. Similarly, is the reverse also true? Is it an attribute of sovereignty that you can cede territory? Can you give away territory? That's the first question. The second question is, when the acquisition of territory is expressly mentioned in our constitution, expressly, but there is no express provision giving the power to the Constitution, to the Union of India or to Parliament to cede territory. How can we read a power between the lines when it is not being expressly mentioned in the Constitution? Which begs the third question, can there be powers in the Constitution which is not expressly given? Or are we bound only by the black and white or express text of the Constitution? So let me mention my three questions again. One, if you have the power to acquire territory, do you also have the power to give away territory? Number two, when the power to acquire territory is expressly mentioned in Article 1, Subclause 3, Subclause C, and there is no express mention of the power to cede territory anywhere in the Constitution, then can we imply that such an attribute of sovereignty exists which gives the power to the government to cede territory? Number three, if we are willing to accept that there is an implied power to cede territory, is this permissible in a written constitution? I mean, we are proud that we have the longest written constitution. If on top of that written constitution, we can also now find constitutional conventions hidden away between the lines and unwritten constitutional provisions, then ours is going to be a lot longer than even being the longest written constitution. So are there hidden depths to this constitution? So there are many issues. So let me start with the last question in a generic way. Is it possible for us to discover constitutional conventions which are not expressly given? Now, a constitutional convention is an expression that comes to us from English constitutional law. And that is a constitutional tradition which has no written constitution by and large. It has had no written constitution. It's a British constitution which is unwritten. And therefore, it is no great mystery for the British House of Lords to have discovered, unseen dimensions and go on discovering unseen aspects of the Constitutional Convention. So A.V. Dicey has written this most famous book called The Law of the Constitution, and he has expounded an entire treatise on a non-written constitution. Okay, so I can argue that fine, let UK have its written conventions, unwritten conventions, because in any case it doesn't have a written constitution. Why do I have to accept unwritten conventions into a written constitution? However, you will notice not only in Article 1, but when I come to the third unit, dealing with the power of the executive, you will realize that when I come to the powers of the president, we are going to discover that there are powers of the president which are written in the constitution, but there are also unwritten powers of the president that begin to operate in the form of constitutional conventions. So not just in the part dealing with territory, but also in the part dealing with executive. We are going to be studying unwritten constitutional conventions, and we are going to accept that these are part and parcel of the constitution. Now, at this point, you could ask a question, why do we accept it? And the reason we accept it is that we are not writing on a clean slate. Some of the powers, for example, the power of the head of state, has come to us. Just one moment. I need to charge my battery. Just give me half a minute. Giving you the answer that yes, we do accept these unwritten powers of the Constitution. Why do we accept it? In the case of Article 1, we accept it because we say that a sovereign power should include the power to accept, and it should include the power to give away. If you don't give plenary or complete powers to a sovereign, if we don't give plenary and all-encompassing powers to If we don't give plenary powers to a sovereign, then that would not be a sovereign at all. And therefore, since the preamble says India is sovereign, all the attributes of sovereignty which are recognized in international law, up to and including ceding territory and acquiring territory, must be seen as an attribute of sovereignty. So notwithstanding the silence, there is an expression, sub-silentio, that even that which is silent will be treated to be part. And when it comes to the executive, are there powers of the president which are not expressly given? There are powers there, but the reasoning is not one of sovereignty, but I'm not going to deal with it. I just brought it up in order for you to recognize that Article 1, subclause 3, subclause C, where I'm telling you that the Supreme Court says you do have a power to cede. The justification is in order to have completeness to the sovereignty that India has, and to give all attributes until now recognized that a sovereign power ought to have. The reasoning why we accept certain other unwritten parts of the constitution when it comes to executive is not because of the logic of sovereignty, something else, but I'm not going to deal with it now because it's just going to cause confusion. Okay, but just so that you know that there is these constitutional conventions, and this sort of explains to you why the constitution needs to be read at so many levels. If you remember in a very early class, I had told you that Professor Upendra Bakshi talks about the actual text of the constitution, as he puts it, as C1. And then the interpretation of the courts, which expand or delimit the different words of the constitution and its interpretation, he calls as C2. Okay, so, one of the American well-known judges called Chief Justice Justice Marshall, he said we should never forget that this is a constitution we are expounding. So the power of the Supreme Court as the interpreter and the final interpreter of the constitution. So even when an amendment is made, the amendment may be made by Parliament, but the interpretation of the words is that with the Supreme Court. So, there is this finality and this all-powerful finality, even with regard to an amendment which the Supreme Court claims for itself. It's not written in black and white, but the Supreme Court has claimed it. There is no basic structure written anywhere in our Constitution, yet the Supreme Court has claimed it as one of the underlying principles. So in several ways, the Constitution consists of just C1 and C2 also. That's what Professor Bakshi says. So in fact, I think yesterday in class I was mentioning the day before, I enjoyed reading this article of Professor Bakshi in the Indian Express, where he says after the text of the Constitution, the Keshavananda Bharati judgment is the second most important text of the Constitution. Okay, meaning thereby that the interpretation also is the C2 as he puts it. Okay, therefore I've answered all my three. Now we are coming why we have to have this implied right read in, and then should this implied right, does it include the right to secede? And I said yes. But now what I want to find out is to find out how the Berubari judgment arrived at that position. And once you have the power, how will you exercise the power? And please note the true distinction between having the power and deciding how it should be exercised. You have the power because you want to have completeness to the attribute of sovereignty, which has already been declared in the preamble. But how will it be exercised? Now, how will it be exercised? The acquisition of territory is provided to us in somewhat great detail in Article 2. So let me come with acquisition first. It's a simpler case compared to cession. Look at Article 2. Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. So Article 2 is providing you a mechanism by which territory which is acquired can be brought into the Indian Union. And what is the mechanism? Article 2 says Parliament is the body, and Parliament using its legislative power will be the mechanism by which it comes in. It says Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. So it may first admit it, and then it can decide whether that new bit of territory should be a new state, in which case it will be governed by Article 2, first schedule and fourth schedule, or as we saw yesterday, it could go, the mechanism could be in Article 3, where it can take a little bit of territory and attach it to a pre-existing state. And that was what happened when the state of Chandranagore was handed over by the French to India. It's contiguous. Okay, here we go. Contiguous meaning territorially the borders are shared between this piece of land and a pre-existing state. And therefore, instead of creating a new state under Article 2, we went to Article 3, where we know you can increase or decrease or diminish the area of a state, or attach a piece of land from an existing state, or a de novo piece of land and make it into a state. And that's what happened. Now look at Article 2 as well as Article 3, which explains to us how new territories which are acquired are brought into the territory of India. Please look at the two-stage process. One, India acquires those territories. The Union of India acquires those territories. And then it brings it into the territory of India. So I'm using this to explain to Articles 1, 2, 3 and 4, and I'm now going to go back in some detail to Article 1. The reason I very quickly went...
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।